3, 2. Welcome to the night studio at the Newseum in Washington, D.C. I'm Gene Policinski, the Chief Operating Officer of the Newseum Institute, and we're here today to discuss a subject that I think is really dear to the heart of not only the First Amendment and the Newseum, but to, as my first editor once said, every parent only has really two concerns, and one of those is education, and the other is their children outside of school. So I think it's a topic that is relevant to the mission here in so many different ways that we're just delighted to have on our stage today Professor Catherine Ross, who is a professor of law at George Washington University Law School, a specialist in constitutional law with a particular emphasis on the First Amendment along with family law and policy issues concerning children. We're here. Professor Ross is the author of a new book, Lessons in Censorship, How Schools and the Courts Subvert Students' First Amendment Rights. So there's a real key to the subject matter and to the, I think, the approach to this subject there. But I will tell you that in going through this, I think it's also a tremendous primer on just why do we have free speech? Why do we value that so much? And so I thank you first off the bat for that.
Thank you, Gene, for inviting me.
A pleasure. Currently a visiting scholar for this year at the Harvard Graduate School of Education. Professor Ross is a former chair of the ABA Steering Committee on the Unmet Legal Needs of Children and served in a wide variety of ABA committees. Prior to entering academia, a litigator at Paul, Weiss, Rifkin, Wharton, and Garrison in New York, and before attending Yale Law School, on the faculty of the Yale Child Studies Center and the Bush Center on Child Development and Social Policy at Yale. But thank you again for being with us and for a rather extraordinary book that I think takes, what would we say, fair to say, 90 years really of focus in the courts, but even more than that, I suspect from the very first day of school, the question was, what can students say and how can they say it, and who will, if anyone, set the limits? You mentioned a sort of constellation of cases that you begin with Barnett in the early 1940s, having to do with flag, the Pledge of Allegiance to the flag. But then you do the sort of, I always say, this sounds to me like that old Tinker's to Everest Chance baseball play. It's really, it's Tinker to Frazier to Hazelwood to Morse, which is a quadrangle, I guess, of cases that define first what are student rights, and then, as I'm fond of saying, telling them students increasingly that you park them in the principal's office until you get out of school, whatever you're at. But let's talk for a moment about that landscape.
Sure.
We do a survey, as many of the people here in the night studio or watching us online know, every year called the State of the First Amendment. We just ask, what is in the First Amendment? And speech is the only one above half, but it's right hovering at half of the respondents. And after that, it's 20% or lower almost every year in terms of just knowing the 5 freedoms. So we're not talking from a posture, as you point out in your book, in a complex subject from some base knowledge. So let's talk for a moment about those cases where you see this issue of student speech first arising.
Thank you. As you mentioned, most people talk about a quartet of student speech cases, starting with Tinker in the late 1960s. But I think it's important to go all the way back to the most fundamental case, which is West Virginia Board of Education versus Barnett. And one reason that's important is that today some people, even constitutional law scholars and judges, think that First Amendment rights for students are somehow off to the side. They're a small issue. And I show, from the remarkable number of circuit court and bank decisions where the full court meets on an important question, that these are at the highest level of controversy and analysis. But Barnett was one of the very earliest free speech cases, and it dealt with the right of students to refuse to salute the flag and to say the pledge. And these were Jehovah's Witness students, so it could have been decided as a religious exercise problem. But Justice Jackson, the former Attorney General for President Roosevelt, who appointed him to the court, he decided to make this a big inquiry into the meaning of speech and the reasons that people are free to disagree. And he says, for whatever reason that motivates you in your personal value system, you have the right to form your own views. And the government simply can't demand that you subscribe to orthodoxies. And this was in the middle of the Second World War. The war had already begun. People were in a very patriotic mood. It would have been too easy to dismiss student rights, but he said this is hard because it's our own flag.
And actually, they had to step back and reverse a decision that they had made just a few years earlier
Just 3
involving
years earlier,
little Billy Gobitis.
The court had said no right to be exempt from the flag salute. And the stakes were very high because these children were often treated as juvenile delinquents, sent to reformatories. Their parents could be cited for criminal violations for violating the compulsory school laws. This wasn't just, do you get to say the pledge or not? And that law and all of that case and all the doctrine that it established remains good law. And it has very inspiring language about why this matters more than any place in our schools where we are teaching students whether we mean it or not when we say people have rights. So now we fast forward to the 60s, another very tumultuous time. And the Tinker case is often thought of as the first speech case for students. And these were students who wanted to participate in a national demonstration wearing black armbands to protest the war in Vietnam and call for a moratorium in fighting over the Christmas break. And their school actually made a special law just for them, which violates every First Amendment principle. They said, no black armbands in school once they heard about the plan. And some of the students still wore the armbands and they were suspended. And the court said, the Supreme Court, in an opinion by Justice Fortas, who also wrote our most important decisions about the rights of juveniles in the juvenile justice system.
Interesting that you have that linkage in
Yes,
terms of...
and a connection no other scholar has really focused on. He was a very special advocate for young people in his brief time on the court. He said, the life of the mind, the marketplace of ideas, is nowhere more important than in our schools. And it's obviously protected in the classroom. But now we need to ask, is it protected on the rest of the campus when there's a conflict between students' consciences or liberty and the rules that are imposed by school authorities? And he came up with a special test. He said, it's true that schools need to be orderly and education needs to take place. They can't be in chaos. But because of this, we're not going to say that that means students are stripped of rights when they enter the schoolhouse. Neither teachers nor students lose their rights when they enter school, the opinion says. So we're going to have a special test. And schools may not interfere with student speech anywhere on the campus, from the classroom to the cafeteria and locker room, unless the speech threatens material or substantial disruption, we read in, of the educational process, or collides with the rights of others. And now we need to figure out what those phrases mean.
I think people are often not aware that free speech protections essentially weren't litigated really until we can begin with 1918 and roughly, that period. I think there's again assumption that we've always had these free speech rights from the very beginning. We might have, but they weren't applied to states up until something called incorporation came along and they started applying it places like schools. So schools are state actors, first of all. That's something people sometimes are surprised to find. There probably is no more essential question in this than I got the view that some would have that schools are really a place where you say to students, sit and learn. That it is not the moment for you to formulate an opinion, and you talk about this in the book, that it is essentially for a time where you're an empty vessel to be filled with the knowledge of others, at which point you will some moment become ready to express yourselves. That's certainly not what Tinker was about. That's not what Justice Fortas is about. What about the person who says that up until, and in law we do divide, children in some states under 6 can't testify, aren't seen as proper. between 6 and, depending on the age, 14, 15, a judge can interview to see if you can give testimony. Above that, there's a presumption you can unless someone knocks it down. And then you finally reach full adulthood. So we have stages in law where we sort of recognize a difference in this. But the formulation of opinion in your book, and I think in Tinker, really said at any age, children have a capacity and should be not necessarily even encouraged, but permitted or not interfered with. What's the best?
That we should
way to put
listen to what they say.
Okay.
That it's valid to speak, even if you can't fully support your views. And the whole First Amendment idea of the marketplace of ideas is about letting all the ideas out, let them all rise, and see which ones survive. So the First Amendment says the information that turns out not to be true helps us refine our thinking about the information that is true. So children may be parroting ideas they've heard at home. They may be trying ideas on to see how they feel, and at different ages, they'll have more or less ability to back up their ideas in the way that adults would like to see people do, but that doesn't mean their ideas are worthless.
Another issue you talk about as sort of a base level issue is the idea of parental authority or engagement. You know, I think there are certainly those parents who would say, I'm in charge of my school, my child's development, and school is a mechanism by which, and I'm going to be the authority. And then there are others who really would, I guess, replace parents in effect or take their place. Is that a fair judgment on why we have this debate over what children can say?
Well, it's one of the reasons.
Sure.
To the extent that we think of children as belonging to someone other than themselves, or as Chief Justice Rehnquist once put it, children are always in some form of custody, either their parents or the states. We have to figure out who gets to inculcate values with children. And the way that our society has dealt with that is during the school day, the state gets to make the choices about what ideas children are exposed to. And the rest of the time, traditionally, and we can come back to this later, the school gets to decide. So the choice that parents have is how to comply with the compulsory school laws. And the Supreme Court has said you can comply in a recognized licensed school that is not run by the state or a public school. And in recent years, every state has also said you can homeschool. And
now,
then you get complete control.
And to be a mild devil's advocate, if there is such a thing, people would say that the school makes its decision on what to teach on a sort of consensus by whom we elect our school board, so
Yes.
that it isn't seen as a sort of antagonistic third party. It is a reflection somehow of the electorate.
Our
and
community
sense
So
of
there may be some
engagement.
directives from the federal government, from the state government, and then a lot of local decision-making about what textbooks will we use, what subjects will we teach, what languages will we offer.
So Tinker sets out the idea that you don't leave your rights at the schoolhouse door necessarily, and sets out what the one is most commonly associated with, I guess, is this substantial disruption of the pedagogical process, which I always point out is if you can take a lot of statutes that apply to prisoners and drop in the word penology into pedagogy, you have many times the same language, which is another program perhaps for another day.
Yes,
But,
a school is not a prison.
But there's the second part, which is not as well emphasized, and we'll just pass by it, but I want to acknowledge it, which is this idea of intruding on the rights of others. And that's coming up with cyberbullying and
Yes.
in some other ways. But we have this idea that the default is speech, if you will,
Absolutely.
in Tinker. And by the way, Mary Beth Tinker's armband is upstairs in the First Amendment Gallery. She has loaned it to us, so we can go see that. But then you spend, as a society, not you, as a society, we spend the next 50 plus years limiting Tinker.
Yes.
And in some ways trying to dissemble Tinker. And so we get to those other cases. And
Yes.
so in order, Frazier, I guess, would be next.
Yes. So Frazier was a high school senior who gave a somewhat salty nominating speech for his friend who was running for school office. And
Theater of the mind, in many ways,
yes.
for those of you who ever get a
Just
chance
full
to
of
read
double
it.
entendre, but nothing, no bad language. You know, if you didn't understand it, you wouldn't get it. And he was punished after the fact. And the Supreme Court said, schools have a right to control what it characterized as lewd language, and really in their discretion as part of the civilizing function. Right. So that's an area where people use curse words, talk about sex in a particular way, the school can control it. That was a small hole in Tinker, but then we get to Hazelwood.
Right, which Fraser wasn't seen as an assault on Tinker.
No,
it was sort of refinement, I guess, would you call it?
Yeah, can we ask the kids be polite in school?
Yeah.
And even Justice Brennan, one of the most vehement defenders of First Amendment rights, went along with that decision. But then 2 years later, there was a case involving a high school newspaper. And it was taught in a class for credit, so it could have been a very narrow case about work produced in a classroom with a teacher's supervision. But the court was actually very activist in moving in a conservative direction. There were 2 articles that disturbed the principal when he saw them. One was about girls in the high school who had been pregnant and the risk that pregnancy could happen to anyone and that you should be aware of it and practice what we today would call safe sex. And the other was about the impact of divorce on some of the families in the school. And instead of giving the students a chance to fix the articles or just excising those 2, the principal ripped 2 pages of the newspaper out.
Literally.
And just said, none of the articles on these pages are running. And the students, again, went to court. And the decision was a very big problem for defenders of student speech rights because it defined a new category of speech, school-sponsored speech, which really means speech that seems like it's the school's own, but it defined it very broadly, not just as classroom speech supervised by a faculty member, but anything that has an educational function and has faculty supervision. So it reached all of the speech and extracurricular activities and many other things, so long as somebody looking from the outside, not knowing the facts, would think that the school endorsed the speech. And if it's school-sponsored speech now, the schools can censor it or punish it, 2 aspects, stopping it from appearing or punishing the speaker afterwards, for any pedagogically legitimate reason. So they still have to have a reason. It's not unfettered discretion, but it gives schools an enormous amount of power. And if it's school-sponsored, judges are very reluctant to say the school went too far. And the final one was the case that most of you recognize as the Bong Hits for Jesus case, which actually Morse versus Frederick. And in that case, again, the court said, we can't get to the result that they didn't actually say this, I'm paraphrasing, the existing tests won't get us where we want to be. We're making a new rule, which is not the way law is really supposed to work. And so they said that schools may limit speech that appears to promote the use of illegal substances, which is illegal drugs and underage alcohol. But some courts are now pushing further, and some schools are saying anything that conflicts with our message in a way that could endanger students and get them to do bad things is covered by this case.
I think 2 months after Morse in Missouri, a district court judge cited that decision on drugs, had to do with something entirely different, but saying in effect that message idea of the schools. Morse recognized, again, I think as you discussed, the larger missions we also impose in our classrooms, the larger missions than just a reading, writing, arithmetic idea, not her words, my cliche. We also, by the way, have the Morse banner, the Frederick banner upstairs with the Bong Hits for Jesus banner in the First Amendment gallery. If you're looking at Ms. Tinker's armband, look up and to the right and you'll see it. I would point out.
We can all walk up together after
also adjacent to Bart Simpson, but that's another story as well. So now we have this environment where we're moving from, I think a fairly broad platform for students to speak into there's a limit here, there's a limit there, there's a limit on this. It's speech, it's valedictory addresses, it's student publications in certain circumstances. And then Morse takes it to across the street into what is traditionally a public forum, a sidewalk. After school is adjourned for the day. This had to do with going to watch the Olympic torch run by the classroom, I think in Juneau,
Yes, in Alaska.
For the Olympic Games being
So the
held
principal said, school's over, but everybody's going across the street.
there. Yeah.
So is that really off campus or not? And there were teachers there supervising. And actually, Joe had not checked into school that day. He came late and just went to the rally, so that's another wrinkle. But Justice Alito said, this is as far as I'm going in reaching off-campus speech.
However,
rest of story.
Right. Courts, or at least administrators, are now reaching far off of that physical campus or location to speech that is performed by students, say, on a break or in the evening, on computers or devices now, we have to say, provided by their parents.
From home.
From home. And they're acting, I think, even in the most extensive fashion when it's not even a subject necessarily about an educational involvement with the school, but it is more commonly something about a teacher or a fellow student. But even if the student didn't intend for it to ever be circulated at the school. So and you talk about it here, talk for a moment about where are we headed in terms of both society and law, in terms of where does the schools reach, stop? At one time we would have said the parking lot or the physical boundary.
The campus.
The campus. Clearly we're beyond that, and technology takes us to somewhat argue beyond that. Where would you set, if any, or where is the law setting it now, if it's caught up?
Well, this is a very disturbing trend. As you said, the school administrators have made very, very broad claims, including the claim that they can address speech wherever it happens that they hear about and that is offensive. Offensive speech is exactly the speech that the First Amendment protects, and that Tinker expressly says, democracy, the Constitution says we have to take the risk of being exposed to offensive, disputatious speech. And so what these schools are claiming is the right to discipline speech that they couldn't even discipline in school under Tinker or Hazelwood. So that is frightening, and it really gets to the heart of some of the debates running through my book. Is order more important than liberty? Can we find the proper balance between them, which isn't always easy, but it's an important task? Or are we communicating to our students that we are, in fact, an authoritarian society, that the authorities always win and they're always in control, and that we don't mean what we say in the Bill of Rights? And that's what concerns me most in terms of the future of democracy. The courts so far have not accepted what the schools are trying to do. And the schools have pushed to expand the boundaries of their right to control student expression in every of the doctrines that currently exist. But the courts have said no. Either it's totally off limits if it's off campus, or the school has to show that the speaker intended it to reach the campus and to create disruption there.
So merely sending something to someone else who then circulates it at school wouldn't necessarily meet that test for you.
Exactly. Okay. So a common example would be somebody who puts something on a closed Facebook group. It's open to only 20 people. It's not open to the public. And someone who gets it shares it with more people. Or even more confounding as a matter of law, a parent comes in, tells the principal, there was a nasty comment about one of the teachers, and you should go to this site and you'll find it. The principal opens it and says, the speech appeared in school, we can discipline it. It's insane. Insane is not a word I use in the book. This is more conversational.
It's okay. I think we know where, at least I have our own views. I would agree with you. So the new factor, in a way, because we're talking about laws in the 40s, 60s, and 80s, is that pesky web and all the mobile devices and all the rest. again, following this issue on almost a daily basis, there's almost an argument that things are different now, that no judge or principal wants to be the person who ignored certain kind of speech, and then there's violence in your school, and you could have anticipated it, so to speak, by removing a student or silencing a student. Parents are, for the first time, I guess, over the last 20 years, looking at schools as dangerous places instead of places of safety. I think we all remember those programs that said if you're walking home or you're somewhere and you fear, go to a school, if not to a home that had a little placard in the window. Is this a reflection to some degree about just the nature of our view of schools and their
Oh, there is so much in that question, Gene. Where to start? I'll go backwards from police in the schools and what that can lead to, and their role in enforcing some of these rules. Students are arrested in school, handcuffed for speech violations that are for exercising speech rights that are fine outside of school. But going backwards, does online speech profoundly change all of our understandings about speech rights? Every time there's been a new form of media, people have said, this is a disaster for children. This is the game changer. First Amendment doctrine no longer works. First Amendment doctrine has proved amazingly adaptable and flexible to comic books, to video games, to movies, to television, to radio. All of these things made adults panic, and we have survived as a society. Now, I'm the first to agree that online speech is a little different. It's more permanent. It travels faster. It reaches many more people. It's a little harder to control. But the doctrines that have served us so well for over 200 years, I think, are sufficient to enable us to respond in a socially responsible way that also protects expression.
When we look at maybe the most recent battlegrounds where there's a push, is there a trend? Is there a kind of litigation today, or is it just maybe it's the online speech that is the greatest threat to Tinker? I think we have a couple of cases from that era in terms of defamation, Times v. Sullivan. There are a few cases that were these sort of guideposts for so long that are really under attack by many people today for, again, as things are different now, kinds of arguments. Is there a particular type of litigation, parental authority, or is it the off-campus that really is
I think it's the off-campus that's scariest to me.
Uh-huh.
I don't think the court is going to get rid of the speech exception for defamation. So there are a group of categories of speech that are not protected by the First Amendment, that are seen to be outside of it based on their content. And one is defamation, one is obscenity, one is incitement to criminal activity. The court has said very clearly, the Roberts Court, we're not going to expand these categories. Which I also see as meaning we're not going to say that online speech is different and that harassment on online speech can be looked at with a lower standard than other harassment law. If it's harassment that meets the civil or criminal codes and can be pursued for either civil or criminal remedies, then I say it doesn't belong in the school. If it really reaches that level of obnoxiousness and threat, then turn it over to the courts where the students' rights will actually be protected and people will be a lot more careful about parsing the law than the school authorities are when they punish students on very little reflection.
There's so much here, again, due process in a school versus the courts. There were competing cases was it the Second, Third Circuit, I think, on defaming teachers. The lower courts arrived at exactly the opposite decisions in those two. And I remember doing a column about it, effectively saying, maybe if it's this bad, it was middle school students,
yes,
young girls in one case, who wrote the most foul descriptions of a teacher, did get a photo from the school's website, which that crossed over pretty easily. But I remember thinking, if it was that bad, sue the parents who were ultimately in authority, and because this was done,
Yes, and
this
in
was
some
on
states,
vacation
right,
and using computers at home.
in some states, parents can be held responsible for the bad acts of their children. But one of those websites actually said in big letters at the top, I'm not sure if these are the exact words,
Yeah,
this is a joke, or this is a satire. And also, for defamation, it has to be believable. People have to think that it's the truth. And when you read these sites, there was no way that a person would think it was true. They were so vile in their descriptions of what these teachers and principals had done.
Yeah, I think even it wasn't in one of the briefs defending the students, but one of the observations was that certain things were physically impossible, that middle school students may not have actually had. I don't want to go too far into that, but it was, I thought it was a rather remarkable defense.
So you're a little like Fraser in his speech. You guys imagine it.
Yeah, so theater of the mind, I think Orson Welles got there. You also touch on, in one of the chapters, on if there's any more contentious area for people, it is religious speech. And this idea, again, of government there to, First Amendment advocates would say neither favor nor disfavor religion.
Neutrality.
Neutrality. But then you get to protection of particular religious views from harassment, or the idea, a little more standard of mine, of the preaching of the actual use of schools. We come out of a tradition here, and this goes far beyond the book, so you're going to get a bit of my supposing about history, but up until about 1920s, this was a great country for various reasons to be a cigar-smoking, middle-aged white guy who happened to go to a Protestant church. I mean, that was kind of and the rest of it sort of existed in the country. Schools very often opened with a prayer, generally would be Protestant.
Many of them still do, though the Supreme Court has said that's illegal.
So we're not moving from a sort of zero posture in terms of what the schools do. Some have had to shed, some refuse to shed this religious view, and increasingly in a pluralistic society, smaller numbers, although many communities would argue we are all of this particular faith or belief structure, and therefore it's proper. What is the role for a school? You talk about it here, and you describe it rather plainly, but for such a complex issue. The role of school vis-a-vis religious faith.
Schools may not promote religion in general or any particular religion or practice of religion, but they must allow students, individual students, to express their religious beliefs and their views that rest in religion. And so that problem really runs through the book, though I devote only one chapter expressly to it, because some of these controversies, the controversies over speech, touch on our most contentious issues today, from immigration and racial animus to rights for LGBTs and those who are opposed to such rights, and also abortion, of course. In both the opposition to rights for gays and the abortion context, the students who take the more conservative position are usually inspired by their religious beliefs. Not just that this is wrong, but that their religion requires that they speak out and tell people this is wrong. And then schools try to silence them. So first of all, they have a right to say politically incorrect things unless disruption would result. They also have a right to pray on campus and to preach. They can preach even though the state can't. And what's happened is that, and all of these areas of law are very complicated, even for lawyers. In the religion area, the court is currently very unclear what the doctrine is, what the legal tests are, and we're asking teachers and school principals who aren't lawyers to figure it out, and they need more guidance. So they often tell religious students, you can't say a prayer over your lunch, because they think they'll be violating the Establishment Clause, which is the clause that says the schools can't make people pray. And so they are really suppressing a lot of religious speech. But part of the reason for that is the religious lobbyists themselves, the lobbyists for religious groups, who have said religion has been forced out of public space.
You hear it. That's a common refrain we hear in many of the programs we have here. The Supreme Court has thrown religion out of the public space.
Thrown religion out of the public square
1963,
since 1962, 63, when they said no official prayer in public schools. Well, that makes educators believe, oh, we're not allowed to let kids pray in school. But the court has expressly said, when I say the court, I mean the Supreme Court, that's how lawyers talk, it has expressly said nothing we have ever written suggests that students can't pray on their own.
Yeah. I've always said that the real situation is if just go to any place they're having a math test. There's a lot of prayer going on, whether the Supreme Court allows it or not. So let's get back to a very basic level right there. But it is an interesting thing, and of course in the world today, in Morse you had the irony of very conservative religious groups along with LGBT groups combining to defend the speaker in effect, and the school board association defending the punishment. So that was an interesting coalition, I guess, that maybe never to be repeated or not often to be repeated. This is where I worry, and I'm curious. I've read through this, and you speak to it, but I'm just, now that I've got the chance to ask you out loud, that second part of Tinker, the intrusion in effect on the rights of other students. If you wear a t-shirt, and this is an example that comes from real life, you wear a t-shirt, rainbow t-shirt in support of perhaps sometimes a student who spoke out earlier, and this happens, silenced for speaking out in favor of gay rights, and as inappropriate, you wear the rainbow t-shirt that you're protesting it, you then get suspended. But wearing that t-shirt to someone whose deeply held religious beliefs are that this is an inappropriate or a sinful lifestyle, we aren't quite at that point, but we're seeing it in other ways, and maybe more at the collegiate level, which we can talk about. There's sort of what I call the atmospherics as a threat. Are we headed to that sort of collision where just the mere expression of that view brings
I think
in
we
the second
are
part of
headed
Tinker?
to that sort of collision, but it violates every precept of our Constitution. The First Amendment is very clear. There's no right to be protected from views that you don't like.
And in fact, Justice Jackson once called that the contrarian theory. If
Yes.
only to be better armed to argue against it, you need to hear things.
That's right, to know what's out there. But also, if the point of the speech clause is to protect unpopular speech, speech is unpopular because people hate it. And this is freedom for the speech that we hate. So you're going to be exposed to ideas that are unpalatable or worse. And that's the idea of the marketplace. You respond to bad or offensive speech with more and better speech, and you try to convince people that your view is right. So what's been going on now, and I call it hurtful speech, and it's speech that hurts its targets, whether the targets are groups in the aggregate or individuals, as in verbal bullying that isn't accompanied by conduct. The First Amendment protects the right to speak. And so when schools say you may never engage in cyberbullying, they're violating the First Amendment. And one of the things that really concerns me is the federal government is leading the charge. The Department of Education, in consultation with the Department of Justice, which should know better, puts out guidance to the schools saying you have to constrain bullying and you have to constrain hate speech. And then they put in at most a footnote that says, might be a First Amendment problem,
Right.
Fill in, you're on your own to figure that out. That's not the job of the federal government. They should be protecting rights and helping school districts to figure out how to deal with these social problems in a way that is also constitutional.
It again applied more to the collegiate level, but I was reminded of, because I was reading your book at the time, where the phrase was college presidents raising vague First Amendment concerns. And I thought, it was really vague about free speech. But for those of you who have joined us online, let me just do the little moment, and I want to use that opportunity for those of you here in the night studio. If you have questions, please come down to the microphones now. While I do this, this is from the Night Studio. Welcome, I'm Gene Policinski, and we're talking about Lessons in Censorship, a new book by Catherine Ross. And we hope that you will send in questions, and we'll try to get to those if we see them. But we'll have questions from people here in the audience. We've been talking about how schools and courts really subvert students' First Amendment rights in the view of our author. And so we'll move to a couple of quick questions here. We'll start here and then go to our second question on that side.
Okay. Hi, my name's Dave Price. I'm a retired educator and a journalist. And this issue's always been big because in the business I was in, but actually it started as a student when I was, I guess, 15. I wrote a headline in the school paper said about a girls' tennis thing, just said, girls lust after upper birth. I thought it was really clever. They deemed that it had second meaning. I just played dumb. And so maybe I'm a little super sensitive to that. I'm still here, so I survived that. But the idea is, and I mean, to me, what you say is so simple, yet educators make it so difficult. You use two I words. I spent a lot of time on this issue and still do as a consultant from time to time. Ignorance and insanity. And sometimes when you look at what happens, they really are. We can't really do anything about insanity because they're going to be hired despite what we do. But we can do something about ignorance. How do you think we can make those, in light of we have helicopter parents now, we do have more violence in the schools, we do have this new technology that's never existed before, et cetera, all of which could be covered very simply, but apparently people aren't getting the message. What do you think we can do to help educators, and by educators, classroom teachers, but even more so, where the decisions are being made? And I think it comes down to alleviating their fears and then giving them the knowledge. Certainly there is power. Just before we walked in here, I saw on Twitter where the president of the University of Missouri resigned today, just before we went in. And of course that came to show that there's still, whether it's good or bad, it still shows that there is power with those kinds of things. So when the administrators say, I don't want to deal with this, how do you answer that? What would you do?
Oh, it's a fabulous question. Ignorance is a huge problem. Most of the schools of education don't even offer a course that covers this area. If they do offer a course in school law, it may or may not cover First Amendment rights. So we need to, and even for people who are going for their graduate degrees in education, who want to be principals or school system superintendents, are not required to learn about this. So I think that's a very important place to start. The judges also have to help clarify the law. And it's true that in these cases, the facts are very significant. We have something called constitutional facts, where the doctrine has to be applied based on a very specific set of circumstances. So every case can look quite different, but there are still general principles that can be distilled and that can be clarified. And the courts need to help us do that. I have some suggestions, but mine aren't enforceable. If an appellate court clarifies, then people have to listen, and that's the law where those people live. And by the way, we have different legal regimes in every part of the country for every question that the Supreme Court hasn't answered, because it depends what the appellate court in that part of the country says. And I have a map in the book to help lay readers try to figure out what the law is where their children go to school. So that's part of it. But there is also denial, defiance, and just plain refusing to accept the law. And also what I would call caving into pressure from the censorious, because there's so many incidents where one parent comes in and makes a demand of the principal. My kid told me there was somebody wearing an anti-war shirt. I think that's awful. My son is in the Army. And the principal says, oh, I don't want a big controversy. The cases all say clearly, you cannot silence speech to avoid controversy. Controversy is part of the Constitution. So principals say, oh, short-term problem, get this parent out of my office. Right. And so we need to help principals understand they can end up in court for a different reason. But we also need to get the people who favor rights, who understand why they matter to our system of governance in our society, to be more proactive, to speak up before there's a problem, to elect school board members who care about liberty, and to tell those members, we're going to back you up when the censorious come in and complain about a school play.
You know, we were talking also earlier, if you look at the legal advice, you know, and again, there are waves where these are trends of pushing limits and not, but generally lawyers are risk adverse. They're really taught in law school not to win in court, but to keep out of court. You go to court, there's always a chance you could lose. So the best way is to avoid going. And very often now that's this sort of activity is close it down, shut it off. So even in the legal climate, you have this tendency now, I think, that's where the sort of tide is extinguish it, keep it silent, and keep out of
Well,
keep
I
out of
also
court.
think lawyers should do a better job of advising their clients when their clients are school districts. So instead of saying the law allows you to silence this speech, a lawyer can also be a counselor. And when I was in practice, I counseled my clients often to say, well, the law might allow you to do this, but you might not want to because, or there's another way of thinking about this problem. And I'd like to see more of the lawyers play that active role in fostering the values of the Constitution.
I don't want to monopolize the conversation, but I do have one other thing that I want to ask. What is the constitutional protection for the device on which you make the free speech? This is the cell phones now issue all over the country. I mean, obviously you have the right of free speech, but if this is the way you make it, where does that fall under the rights issue? Do schools have the right to completely ban cell phones? Not? What do you think legally?
To ban cell phones from school,
Right.
yes, they appear to, as you know, just as they can say you can't bring baseball bats, you can't bring knives. You have to park them outside. I'm not aware of any court decision on this, but my guess is they can. But a cell phone does have an expectation of privacy, absent a warrant, and the Supreme Court has issued a decision on that came just as I was finishing my work, where they said it has more information than the most intensive search of a person's home. And so there's a privacy expectation absent a warrant. But school officials see cell phones and iPads and laptops and demand the passwords even when they don't have good cause.
And that raises this issue of due process again, that whether schools, by becoming in effect a judicial body, and have a greater requirement, and many of them fail in terms of the due process protections, which ironically is another reason to turn to the court system where those processes have been built in over the years. But again.
Right. And it's not that I clearly don't want to send more children into the juvenile justice system, but for some of these things that might result in a fairer treatment and a more considered judgment about whether this is something the society should be pursuing.
Question here. Hello, how are you?
Hi, how are you? My name is Li Yang. I just wonder, is any study at all, they will tell you or analyze the system, the data, they say, in a sense, the systems go deeply into the school system. And in a sense, it's the students who are really smart but will be labeled inferior, and the people, system, the student will criticize or say the teacher is wrong, or community policing somewhere is wrong, or administrator is wrong, but they will be labeled mental ill, and they just go more intensified, then eventually the student cannot really stand it, they really run crazy type, so they continue to label mental ill, and will not allow the student to speak, and will really penalize and stay outside the classroom and things like that. Is there any study of just saw they will be making the system worse and worse, the student cannot go progress anywhere?
Well, I know, and you're a frequent guest and welcome here. If I can summarize the question quickly, I think, what about schools using these sort of alternative descriptions, mental illness or even incorrigible, if you will?
Yeah.
Because you do have that experience at both the juvenile delinquency area and student speech. Are they using that subterfuge, or actually they're just going straight to the idea of shutting down speech because they don't like it?
They often use the category defiant speech, which I think is quite similar. And one of the penalties for some of these student speakers is being sent to an alternative school, which is a designated school for troublemakers or people with mental health problems, even when there's nothing in the record beyond this one speech event that suggests that the student shouldn't be in a regular school. So to some extent, that is a fair observation. Yeah. I can't say that we have data about it, and in general, we have very little data outside the reported decisions. We have a very hard time even knowing how many kids are arrested at school. We just don't collect this sort of information.
I think even in the Bongheads for Jesus case, wasn't the student suspension originally extended because he quoted Jefferson or Hamilton or Madison in trying to be defiant to the principal of the initial suspension? Wisely later reversed, I believe.
Yes,
so
yes.
I would, as a teacher, I would have been really happy for students.
Yes, you've read something.
There had been some educational process going on, but
Right.
but I think they later backed down
Yes.
from that. You have, and maybe this will also speak to the couple of questions, a small chart in the book, before you silence student speech, which is really, I thought, sort of comes under what I used to call the handy-dandy guides to the First Amendment. But it talks about stop and identify the type of speech. And would you mind running through that if I can?
Sure.
I'm terrible, by the way. No one ever wants the books I have because I pinch corners and I put stickies all over them. So
It warms
hope you don't
my
mind,
heart.
but,
You actually read every page, I can see. Okay, so this is a gross oversimplification, but it's in part my effort to respond to the puzzlement that the people who have to make these snap judgments experience. So particularly if a school administrator or a teacher thinks that there is a risk of material disruption, you can't say, oh, I'm going to call the lawyer, I'm going to ask him to write me a letter, which I'll get next week, and try to figure out, is there a danger here? Is there a threat to our security? You have to decide, am I going to pull this kid out of class, segregate him until we find out what's going on? So I just wanted, assuming that we've changed all the schools of education, all the teachers and principals have read my book and understand it, and now they just have to decide, somebody calls them, we have a problem in this classroom. So I say, before you silence student speech, and a stop sign. I'm hoping to do posters of this with color. A good friend of mine who's a graphic artist helped me with this. First, you have to identify the type of speech, because as I've been explaining, depending on the type of speech, a different legal test applies. So is it what I call pure student speech, the student's own speech occurring on campus? Then do not silence it unless you reasonably anticipate material disruption or it collides with the legal rights of others, not their right not to have their feelings hurt. If it's school-sponsored speech, it appears to be the school's own speech. Those are Justice Alito's words, and I think they really capture it very well. Slow down, again, a traffic sign. You may censor it for a legitimate pedagogical reason. So that means first you have to decide, does it really look like the school's own speech? And then, do I really have a legitimate pedagogical reason, or do I just not like the speech, in which case I can't silence it? Or is it unprotected? In other words, if it's unprotected and there I have a go sign, you can censor and punish it. If it's lewd, pro-drug, but not political, threatening, because threatening speech is never protected anywhere, including school, inciting violence, or defamatory. And so I think that's just a shortcut, and I think of it as something like the Heimlich maneuver sign. I'd love to see it in every principal's office, just like you have the Heimlich maneuver sign everywhere that people eat out in public.
When we...
And can I just say,
please.
I do hope to make it available on my website because I have a copyright on it. So I will supply them if there's a demand,
Very good.
at cost. This is not my retirement plan. It's something I want to see happen.
I think if you're talking about student speech, it's a long way from retirement. We hope that you'll be engaged in that. You know, when parents talk about this, and if I go out and talk about it, and I say the Supreme Court didn't throw religion out of public schools, but the schools may neither favor nor disfavor a particular faith or however, that students start from a posture of having rights, and that we've limited them in certain ways and may continue to do so, but they have that. You know, I think the greatest dilemma for people who generally just have a question about this is very often just the idea of, I've given my children certain values for a period of time, and you can, with preschool now, I don't know how long, 2 years, 5 years, just to do maybe the old-fashioned example till they get in the first grade, and then I share them, and as they move through the grades, lower elementary, middle, high school, and into college, that ability to, for lack of a better phrase, and I don't mean this in a bad way, to indoctrinate or to teach is reduced marginally, at some point to a marginal level. And I just worry about my kids being exposed to the bad ideas, or even if it's the seamier side of life. I'll choose to tell them sex ed, or I'll choose to talk to them about drugs. And this is a flip, and not what a question I'm not comfortable asking sometimes, but where would you set limits? And it's a tough thing to ask, and I don't mean that as we were joking about gotcha question. I don't mean it in that fashion, but that's, and I have to say, full disclosure, I was just doing some speaking in Brazil, and the students there at all levels were so consumed with where would I set limits in their society for speech. I was taken aback by it. But when people generally, who aren't opposed to kids speaking necessarily or sharing ideas, they just want to say, where's the limit? Where would we put limits?
I just want to be sure I'm understanding your question
Please,
correctly.
yeah.
I think you're asking about the limits on what students are exposed to outside of what their parents choose to show them,
yeah.
not about what they actually can say.
No,
Okay.
it's more that.
So exposure to other kinds of ideas or materials. And I don't think that's in a parent's control once a parent chooses public school.
Okay.
One
It's a
way
fair
to
answer.
control that is to go to a sectarian school if you can afford it, and another way is to homeschool. But once you use the public schools, then students will hear more things. But I will also say that students hear things if they take public transportation, if they have any friends who grew up in a different household. And part of growing up is being exposed to ideas that are different from the ideas you heard at home, and trying to decide your own sense of where you are in life, and that's deeply threatening to some parents. But the students who speak up and who are at the core of these cases are almost always actually expressing views that they share with their parents. And one reason for that is they can't get into court as minors unless their parents bring the lawsuit for them. And I'm only aware of one case in which the student was represented by someone other than the parent, and that was an aunt appointed by the judge. So what happens when the students are speaking, they're generally sharing the worldview they learned at home, and sometimes it's a worldview that the school administrators don't approve of. And this is another really important paradox that runs through my book, but also through our constitutional law. We want to inculcate pluralistic values that will make for good citizens of a democracy that includes people from many religions and many cultural traditions and backgrounds, but we cannot force people to be tolerant or respectful. All we can do is expose them to the idea that as a society, we think that's a good way to be. And so one of the ideas that students bring in to school is hate for others or devaluing others. and we have to tolerate that intolerance as part of our pluralism, as much as it might upset us.
Well, the book is Lessons in Censorship, How Schools and Courts Subvert Students' First Amendment Rights. The author is Catherine Ross. Thank you for being with us today, and thanks to those of you here in the studio and those of you watching online.
Thank you, Jean. This was really an honor and a lot of fun.
Thank you. There will be a book signing following this program for those of you here in the studio. Also, it's Harvard Press, I believe,
It
and
is.
just out in last month, so you can order that however you care to get.
You
books
can
these
order
days.
it on any of the usual sites from which you order books, and I suspect that if you have a local independent bookstore, they'll even get it for you.
Well, and as I say, not only is it a great discussion of the issue of student speech, but throughout the book, you really do give us a primer on why do we value speech, free speech in general, and how really the structure that we have around student speech. We do have one more question, perhaps. We have time?
Oh.
I'm sorry, I just wanted to ask a quick question. My name is Joshua Beatty. I'm interning
Can you
out here.
talk just a little louder or into the mic? Thank you.
I'm sorry, my name is Joshua Beatty, and I'm interning, I think the mic might have went out, but I'm interning at the Baptist Joint Committee for Religious Liberty. We have a lot of students that come out and ask us questions, and one of the main questions people like to ask us is, what would you say are the limits in regards to the free exercise clause, in regards to the balance between compelling interest and substantial burden? One of the great things that people always ask is, for example, bullying in school. Where is the limit between where it becomes a compelling interest for schools to step in and actually say, you know, this type of speech needs to stop? One of the big things is bullying in senses where students eventually commit suicide. Is there any point in which the school should step into that?
Well, certainly a school that's aware that a student is suicidal should intervene in some way to protect the student, to get the student counseling. I'm not sure I see the connection between that part of the question and the earlier question about the free exercise rights.
Well, most people with the free exercise clause, they interpret it as the ability or the right to express yourself until you intervene in someone else's life. And is there any point in which you see someone being bullied? Is there any way to set a limit to how far the school can allow that to go on until they decide to step in?
Could you give me an example of a situation that prompted this question?
So for example, the point when someone is being bullied to the point where they go to school and it changes their experience in school. So someone else's speech is impeding on that student's life.
Oh, yes. I actually think I have a proposal in my book, which is at this point, you know, again, not legally enforceable, my idea, and it's called the impingement matrix, where if the speech is really confrontational, in your face, persistent, won't stop when people say, go away, don't talk to me anymore, such that it interferes with the student's ability to get an education, or I would say to be comfortable in school, or to be mentally healthy, that combination of circumstances should allow some sort of intervention by the school.
And if I may, here's where I would parse that out as opposed to the responsibility of school, because we have a body of law.
That's true.
Both in the criminal and civil side, from intentional infliction of emotional distress to conduct that rises to the level of threat or endangerment.
And harassment.
And harassment. So I think sometimes we view this through, again, the filter of a school taking action, when, as I said, with this, you know, these lewd portrayals of teachers, the remedy may actually lie outside the school system. And this gets to a larger point of increasing the burden on schools to do all kinds of things for us as a matter of efficiency. I don't have to sue the parents of that young person who's harassing my child. I can get the school to do it and I can go on my merry way. And to some degree, again, this gets, as you hinted at it earlier, or said earlier rather, the larger, much larger societal questions about the role of school. But if I may, this kind of steps outside the subject matter of the book, but in the sense of, I just think sue somebody. I mean, if I were going to defend my child, I wouldn't look to the school first.
Right. Although, and I definitely agree with that, but sometimes law enforcement doesn't respond
Yeah, on a practical level.
in a practical way or take those kinds of things as seriously as the agency probably should. So you use any means, as you say. If you're the parent or the friend, use any means you can think of.
Okay, thank you. I appreciate that. Thank you.
All right. Well, again, thank you very much, Dr.
Thank you. Pleasure.
Thank you very much. Thank you so much. And again, the book signing will take place, I think, right outside this, this studio. So Dr. Ross will be there in just a few minutes. Thank you.